Hi everyone, my name is Ramana Reddy, and today I wanted to talk to you about an interesting trick that I have that I have seen a judge play against multiple counsels with great success. And this is a trick that you can use in your daily arguments also. So I think the trick is best explained by the actual example as to what happened in court. So the case was, I don't want to take any names, but so there was this renowned senior counsel who's appearing, or the senior lawyer who's appearing before this judge. And the argument that the senior lawyer or the senior counsel is trying to make is that a particular company has been admitted into the NCLT. For those of you who don't know, NCLT is the National Company Law Tribunal. So what would happen is, let us say that particular company owes, say, 1.5 crores to somebody for a contract, under a contract, and that the owner of that company has written an email saying, look, I will pay you the 1.5 crore, just give me some time, and he's still not paying. So there is an admission of liability on record, and the other side is waits, and then he finally says, you know what, there is an admitted debt, you guys are not able to pay, I'm going to take you to the NCLT and I'm going to have your company wound up, or I'm going to have your company closed down so that all the assets and everything can be sold and I can get my money back. It is pretty draconian, but the idea is that if there is an admitted debt and you can't even pay the admitted debt, you should not be in business. So one of the consequences, one of the consequences of getting admitted into the NCLT is that all other cases against that particular company stop, and everybody has to come to the NCLT, and there's a order in which who will get first, who will get second, and so on. And you basically have to come stand in line to get your dues. Now, in this particular case, what had happened was, so the senior counsel was arguing that, look, there is this particular company that has been admitted into the NCLT. So all other cases, so let's say if Ramana Reddy files a case against that company, or there's a case that's pending, that is filed by me on the date the company was admitted into the NCLT, then Ramana would have to go to the NCLT, stand in line, wait for his turn, and then get the money that is due to him. So the argument that the senior counsel was making is look, there's this company that has been admitted into the NCLT, and still there is a tax authority, that there is a tax department person who has examined the company's books, and he said, look, for a particular assessment year, you paid, say, only 5 rupees, you should have actually paid 10 rupees. So he levies that 5 rupees tax on them. Now the senior counsel is arguing before the judge that, look, the tax authority could not have done that, because even the tax authority has to go and stand in line in the NCLT to get his dues. He cannot, once the company is admitted into the NCLT, he cannot stand in line. He cannot, without standing in line, he cannot levy the extra 5 rupees on the company. Now this is just to set the background. Now the judge asks, so this is what the judge says. He says, look, the tax authorities has only said that this much money is due from the company. He's not asking them to pay it right now. Like, there's no recovery notice that is pending against the company. Now, which is a fair point. He's only said that this much is due and payable to you. He's not asking you to pay today. If he had asked you to pay today, then that would be a valid argument that he'd have to get in line. But he's just saying that you underpaid by so much. Now, at this stage, the senior counsel says, look, no, I don't agree with that. Even the assessment, even the affixing of liability, even to say, like, he cannot be permitted to say that 5 rupees is due from me once I'm admitted in NCLT. Like, he cannot proceed. Now, this is where the judge plays his trick. So he asked the senior counsel, okay, so, Mr. Counsel, this is your argument. So let me flip that situation. And let me, instead of levying liability of 5 rupees, if he had done the assessment, calculated the tax, and let's say the situation was reverse, and you were supposed to get a refund of 5 rupees, would you take the same argument? Which, I mean, which is a difficult argument to overcome, because on the one hand you're saying, look, he cannot affix liability, but if that affixation of liability resulted in you getting more money, then would you take the same argument? So I think that's a good trick to play, or it's at least it's a good thinking tool whenever you're talking to somebody thinking about an idea, which is that if somebody is arguing that that such and such situation arose and therefore that he is at a loss, then I think one way to at least to think about the issue would be to try to extract the main principle and then and use the same situation and say, look, if you had stood to benefit from this, would you still take the same argument? Which is like in our case, as I was saying, the senior counsel is arguing that the tax authority does not have the right to even affix liability on me, or to say that I have to pay extra 5 rupees and even write it somewhere. Not that he's asking me today, but even say that this company owes 5 rupees. The judge asks him, well, will you take the same argument if the tax officer does the same calculation and he says, no, you should not pay 5 rupees, but in fact the tax department has to give you a refund of 5 rupees. Would you take the same argument? So I think that's a good way, it's a good thinking tool that you can use whenever you are thinking about arguments, is try to flip the situation and see if the argument still holds good. Thank you for watching.